Good evening. I'd like to call the Shorewood Plan Commission meeting to order at 6:30 p.m. We have Commissioner Klain, Trustee McGovern, Commissioner Wickland, Commissioner Flynn Post, President McCaig. Commissioner Klein and Commissioner Pollock are excused this evening. Is there a motion to approve the September 23rd, 2025 Plan Commission meeting minutes? Yes.
Did I bring this up before there's a motion?
Um,
Do you have to amend the motion if there's a motion on the floor to make a change?
we could just,
We typically amend them within discussion.
that's what I thought.
Yeah.
Yeah. At Village Board, we amend within discussion. So if you,
I'll make a motion to approve.
right, let's make a motion to approve as presented, and then we can make the amendment and approve the amendment. So is there, there's a motion to approve the minutes. Is there a second? Motion by Commissioner Wickland, seconded by Commissioner Flynn Post. Any discussion? This is where you would bring your
Thank
motion.
you, President McCaig. As I mentioned a little earlier to you, before we started, Krista was kind enough to walk me through. There were just a couple of things I wanted to elaborate. Given that I, excuse me, made the motion on the zoning petition, I was hoping for a little bit more detail. Do you want me to read through this or?
Yeah, you could read it into the record.
Okay, page 3 of 22 for item number 2. Mr. Klain stated that he was not present when the village approved the property's current zoning, but he believes that the property owner had the right to ask for the rezoning. He added that given the request complies with the comprehensive plan, is consistent with the surrounding zoning, what is the rational nexus for the village to deny the request? Mr. Klain offered that he is not a land use attorney and recommended the village attorney be consulted. The other item right before we adjourned, I had asked, well, how is the village they gonna get any information about our vote since it's 3-3? And so what I was hoping to amend the minutes to include prior to adjournment, Mr. Klain asked what information that the village board will receive regarding the planning board's action, citing there was a 3-3 vote. He added the board members may wish to know the arguments for both sides. Director Griepentrog stated that he had no objection to providing the village board with the draft planning commission minutes. President McCaig agreed with the importance of the village board understanding the rationale for both sides of the vote. He also stated that she welcomed the plan commission to attend the meeting of the village. Do I need to make a motion to amend the?
What you can do is ask for if these amendments are acceptable, then it could be a friendly amendment.
Yeah, if there's unanimous.
Oh, okay. Any discussion regarding the changes that Commissioner Klain is proposing, has requested? Hearing none, we can take a vote on the motion as presented, and by consensus, we'll be adopting the amendments. All those in favor say aye.
Aye.
Aye. Any opposed? Motion carries. Thank you very much.
Thank you.
Item 3, further discussion of the Plan Commission's proposed initiative to increase housing opportunities in the village. So this is coming back to us with a few items in red to be. Oh, apologies. We had a request to take item 4. Is it item 4? Okay. Thanks for reminding me. I forgot that.
Microphone one.
So I would like to take item 4 in advance of item 3, introduction of a possible amendment to the zoning code with respect to appeals to administrative or village decisions. So this item comes to us from the village manager's office to the attorney to us. There's been a change in the state statute regarding the appeals process and what is who is deemed eligible to bring request an appeal of a decision by the village. And we are updating, the recommendation is for us to update our code to be in line with the state statute. Is there anything else? So there's an amended copied summary in our packet. We just were handed a resource that summarizes chapter 781 with highlights as to what the proposed changes are or how they pertain to our ordinance. So with that, I will let the commissioners finish reviewing that and then ask any questions. And if Attorney Bear, if you'd like to give an overview, you're welcome to do so.
That'd be great. And the reason I handed this out, this is actually a copy of the entirety of chapter 781 of the Wisconsin statutes. And I thought to understand what we're doing and if you get questions from constituents, or applicants that have matters before the Board of Appeals or have questions about zoning, I wanted to get sort of a 30,000-foot view to start this out. So if by state statute, if your municipality has a zoning code, and not all do, some towns don't, and they're by extension, they use the county zoning. If you have a zoning code, you have to have what they call a Board of Appeals. And the purpose of that is to give what we refer to as due process to someone who is going to have a decision made by a municipal official related to that code. Now, generally speaking, the Board of Appeals also has jurisdiction to hear appeals of other municipal decisions that are made beyond just the zoning code. So I'll give you some concrete examples. You come before the body, you seek a building permit, and the village inspector denies the building permit, saying, based on my interpretation of the building code, you're too close to the lot line, or the square footage is wrong with respect to the required green space, et cetera, et cetera. So there's a denial there. Another example might be you apply for an occupancy permit, arguing that you meet the existing zoning requirements. The municipal official disagrees and denies the permit. Now there's a body with which we provide due process, and there's standards, there's evidentiary standards, there's standards of burden of proof, those types of things. And generally speaking, the purpose of that is to provide the due process to the person that had the request to a municipal body. In other words, if I'm the one making the application for the building permit, if I'm the one seeking the occupancy permit and I'm denied, I now have another layer of due process, and somebody else can arbitrate whether the municipal official got it wrong or got it right. Now, that's generally what these things are for. But in recent years, especially in the last decade or so, there's been a trend by outside individuals who have absolutely nothing to do with the application in front of the municipal body, using it as an affirmative weapon to try to block things from happening in a municipality that they simply don't agree with or don't like. I'll give some specific examples. Shorewood has been dealing with 4 or 5, now it's 6, I think, lawsuits relating to the construction of the apartment complex over on Capitol Drive, all of which thus far, every one of them thus far has been dismissed, and then they keep getting refiled or amended. But it wasn't brought by anyone that was issued a building permit to build that place. It was built by, there was a lawsuit brought by outsiders who saying, hey, wait a minute, we don't like the fact that that's going there. So we're going to essentially use or abuse, if you look at it, the Board of Appeals. We're going to come before the Board of Appeals. We're a quote unquote neighborhood association that's going to come before the Board of Appeals and say, oh, we don't like the fact that you issued that building permit. We think it was done wrong. And even whether there's no merit to those that in any way, shape, or form or not, and whether there's no legal merit to those, the Board of Appeals has had jurisdiction to hear those grievances. And then invariably what happens is delay. And the people that bring those lawsuits or bring those challenges argue that, well, wait a minute, we have to shut everything down. We have to slow everything down. You can't build anything until our appeal process, which is probably going to take 3 or 4 years, is complete. So this is the same problem at the state level. There's another layer of the Court of Appeals, if you will. If you disagree with the decision made by the Board of Appeals, you can go to circuit court. And the technical term for this is called certiorari review. It's called certiorari review. And you go to a circuit court judge and you say, hey, judge, I don't like the decision that was made by the Board of Appeals in Shorewood, in Brown Deer, in Wauwatosa, wherever it might be. You go to the circuit court and you say, okay, you're now going to act, the circuit court is going to act as the appellate level. The circuit court at the state level, got so sick of these that they changed who has standing. We call it that the legal term is standing. Who has the ability to bring these lawsuits challenging decisions that were made at the Board of Appeals or other municipal bodies. And the highlighted portion is what specifically I'm talking about. It says an action under this section, and this section means certiorari review in circuit court at the state level. It says an action under this section may only be filed by any of the following. Person who submitted the application for approval. In other words, I made an application for an occupancy permit and I was denied. And so it's my property interest at stake. I think that I have the right to occupy that place or not. That's a person that has standing. Two, a person with an ownership interest in the real property that is the subject of the application for approval. In other words, it's not me personally, but it's my company, or I own the property where the occupancy permit's being sought. I have standing to say, I think that they got it wrong. Three, a person that as a result of the decision of the approval, in other words, the granting of the permit, sustains actual damages or will imminently sustain actual damages that are different and distinct from simply being a taxpayer in the municipality. That's not good enough. You have to sustain actual damages. And it also says that you can't be a neighborhood association that's simply created for the purpose of initiating the lawsuit, because those are getting filed by a certain class of attorneys all over the state that challenge developments that they don't like. And they will form municipal neighborhood associations. We've seen it here. As far as I can tell, the lead plaintiff, which is a neighborhood association, still challenging the now completed apartment complex on Capitol Drive, consists of, as I can tell, the lead plaintiff, possibly his wife and possibly his dog, and probably no one else.
Attorney Bear,
Uh-huh.
we might be going out of
Okay.
scope with all due
Well,
respect.
this is okay. All right. But this is why we're here. Okay. And because at the state level, the reason that this statute was passed is exactly because of those lawsuits, exactly like that. And it's designed to stop those lawsuits. Okay. So then 4 and 5 are basically government entities or state agencies have a right. So one of the questions that I've been asked is, why does this only right now apply to certiorari review or seeking review in circuit court on issues that relate to residential development? Why doesn't it apply to commercial development? And that has something to do with how the sausage gets made at the legislative level at the state. This was tacked on to a bill that related otherwise to residential development. So there's an effort being made behind the scenes now to also change the law to apply this to commercial developments as well. I'm not yet aware of any other municipalities. I sent an email out on the listserv, but I'm not aware of any other municipalities that have done this yet because this law is so new. So the question really becomes, in my opinion, the enabling statute for the Board of Appeals references this statute. They changed that as well. So in my opinion, we can limit standing before the Board of Appeals to mirror the standing requirements that you'd have to bring a lawsuit challenging that decision in circuit court. I think we can do that. The question, I think, is Part C of the statute, where it talks about this action may be filed by, or sub 3, a person that has sustained actual damages. I don't exactly know how you evaluate whether you sustained any actual damages different from a normal taxpayer. I've left that portion out of the ordinance, but basically what the ordinance does is it more or less mirrors Wisconsin statute 78110. And it says, in order to challenge a municipal body here in Shorewood, their decision, you've got to either be the person that applied and was denied, or have a property interest in the property that was affected. In other words, the occupancy permit wasn't granted. Or you need to be a state agency or other municipal body. We're not going to allow people to actively come in and say, well, gee, I don't like the fact that my neighbor, we just had another where this would apply, situation where this would apply before the Board of Appeals, somebody saying, I don't like the fact that my neighbors wants to build a pool, and I'm gonna challenge the municipality's grant of a permit to build that pool. Even though it was issued utterly consistent with the ordinances, we've got an outside individual with no property interest, no personal stake in the matter, essentially tying up time and effort of the Board of Appeals and potentially subjecting the municipalities to lawsuits when they have to defend these certiorari actions down the line. So what I did is, and I think we're on the cutting edge of this, is I basically mirrored 78110. I mirrored the standing requirements that are in the statute and made those standing requirements the same, or virtually the same for Board of Appeals. And again, I appreciate that. The reason that I ventured over into the example of our own municipal lawsuits that we've defended is I've talked to the individuals that actually drafted this. I've talked to those that have presented this at the state level. And I know that the state statute was changed in direct response to those exact types of lawsuits they've seen statewide. And that's exactly what I was told. So, and it's the same pattern we saw here in Shorewood. So that's the 30,000-foot overview. Moving forward, you would not be able to come in and challenge your neighbor's issuance of the issuance of a permit, an occupancy permit, a building permit, whatever. You either have to be the interested party or the owner of the interested party's property or a municipal body. So I think the Shorewood would be on the cutting edge of this if we had had this in place. This law had been in place earlier, back before the recent slate of lawsuits were filed. We would have been saved years of litigation. And I think it's the right path moving forward. And I think it'll save our Board of Appeals time and effort dealing with what in my opinion are often frivolous lawsuits. So
Thank you
that's
for
the-
your presentation. And if I may just clarify before I open it to discussion, the reason why it's coming to the Plan Commission is because actions that the Plan Commission takes could be subject to appeal. And so as one of the entities that participates in the quasi-judicial processes in Shorewood, we're being asked for our support or recommendation to the village board, but this will ultimately go to the village board, correct?
That's right.
Yeah.
That's right.
And then also it potentially saves time on the part of the Plan Commission because one of the actions that a Board of Appeals can take is to remand items back to Plan Commission to reconsider or to, go through the process again to have a complete record, for example. So with that, Commissioner Klain, did you have a comment?
I was just gonna, I guess, ask, it sounds to me like basically what we're doing is tightening up the definition of affected parties to eliminate unnecessary appeals from people that really don't have any reason or real standing to do so.
Correct.
That's exactly right.
Mhm.
Good.
Yes. And as typical, you really don't want, lots of times we will update our local ordinances when the state updates their statutes because you don't want to have something that's less restrictive or more restrictive at the local level. Yes, Commissioner Wicklund.
Yeah, so I agree. Do wonder though, leaving out number 3 from the state statute, with your specific example you gave, I'd like to think with the state statute, the person and their maybe not their dog, but their person,
I apologize.
if they were affected, if they felt that they were damaged in some way by, let's use that example. Let's say I lived on Stratford Court and I was never going to be able to park again. My life was ruined. I mean, you could, under the state statute, you could be a party to a lawsuit, correct?
Well, I don't know the answer to I don't know
I
the
mean, I know
answer to
you're not
that
a judge,
because, well, I mean, but it's a fair question and I absolutely see your point. And you may be right, in terms of whether we include that or not. But here's the problem. Here's the problem I see is how do you define what actual damages that are personal to the person and distinct from damages that impact the public generally? How do you define that? I don't know the answer to that. And I looked and there hasn't been, that hasn't necessarily been litigated, litigated yet. There's one case on it. There's the St. Croix case, versus the Village of Osceola. And it doesn't squarely address that question. It kind of dances around it, but, it says the person under this subdivision may not seek review over the decision or approval. And then it also talks about, that the damage essentially has to be different from those to just the general taxpayer or the general public. And it also says that you had to in order to preserve your right, you had to have come before the body, be it the original body that gave be it the plan commission or another example would be the design review board. You had to raise your objection there at that level before you can get the right to seek certiorari review. So, the problem I saw with that language is arguably it's vague enough that we would end up essentially litigating all the time whether or not someone actually has actual damages distinct from the general public or general taxpayer. I don't know how you answer that. And I think even if we didn't include it, my thought process was that someone could still theoretically, if they met that criteria, they could still seek certiorari review directly in circuit court. And then, we still have to monkey around with it at the Board of Appeals level. But you're right. I mean, I left that out, but we could theoretically add similar language back in.
By the way,
and it's,
I kind of like that it's out. I'm just
Yeah,
saying,
I mean-
I just want to point this out. I mean, I think that what's missing here then, the issue you brought up, like you can't form, even with number 3 in there, you can't form a neighborhood association and have some lawyer represent the association. Who's funding the association? It has to be an individual still, a neighbor that says they're damaged. And I think people say they're damaged all the time. People sue all the time. They have to pay for it. Right?
Right.
And they go to court and maybe they aren't really damaged, but that's typically up to court to figure out. Here, we're just kind of eliminating that. I don't know. I just think that I think neighbors could be potentially damaged by something their neighbor does that gets approved by the village. And this eliminates their ability to fight that.
Wouldn't they still have civil suits available to them?
But not against the village,
Not against the village, it would be against the neighbor. It would be,
right? But the neighbor would say the village approved this, right?
Got
Like,
it.
again, let's say somebody puts up a very large statue of Donald Trump next to my house. It probably devalues my property. I mean, I'm sure someone's not going to move here and say this is great. And if the village approved that, now I don't have a remedy. Now, who am I going to sue? Am I going to sue my neighbor? And they're going to say, well, the village approved this. It's legal in Shorewood. Look at my statute. I just think we're limiting an
there-
individual's ability with the ordinances. And by the way, I don't like lawsuits, so maybe that's the intent.
so, just so that I know are you asking for something to be, are you recommending that
Yeah.
that the commission, are you asking for anyone to do anything? And then I'll
I'm
take
just, we're
that.
having a discussion.
Yeah.
I'm saying that I understand the purpose of the state statute and I understand how it relates to issues we've dealt in the village, and it'd be nice to not have to deal with it. But
Yeah, but Dan, you make an excellent point because, and it's worth discussing because we're in a bit of an uncharted territory because the statute's so new. I sent an email to the other listserv, kind of the other municipal attorneys group, asking if anybody had done what we were contemplating yet. And I'm not aware of anybody has, but, and this is sort of rolled out piecemeal at the state level because they first tacked this on to a different bill related to residential development. So the irony here is a similar lawsuit challenging a commercial development as opposed to a residential development. These standing limitations have not yet been passed for that. So it was, and again, the way it was explained to me is that's how the legislative sausage gets made, is that, hey, we have an opportunity to tack this onto a residential bill that's majorly, related to residential development. Let's at least take the half measure that's available to us now, and we'll figure out the rest later. And, you're always looking for bipartisan support in that. So with the idea that, okay, it's half done, we need to extend this to certiorari review of other types of decisions as well. And we'll get there someday. We're just not yet. So we might be, the first ones to sort of jump this Rubicon so far. And I think we can, because the enabling statute for the Board of Appeals, which says you have to have a Board of Appeals if you have a zoning code, was also amended to reference 78110. So, in my opinion, we can do it. I think, but I do think there is some gray area related to sub 3, and what it means in relation to sustaining actual damages. And if we put that in there, do we end up litigating that as opposed to the underlying issue? I don't know, but I think you raise, it's a very, very fair question to ask.
And I just feel like leaving that out, all those other definitions do not leave anyone other than the applicant.
Right.
It changes the whole gist of this, which may be the intent, right? To make it so only the person that was denied something can appeal, or a government, a local government, but it leaves the individual resident the inability to again.
Point noted. If we can hear from Commissioner.
I thank you for sharing that Shorewood would be on the leading edge of this type of ordinance. And that was my question, was what other municipalities are pursuing this type of strategy? And is this something that is an attempt to address current lawsuits that may be pending? So just I'm trying to understand the timeline for this. Is this
Sure.
something that, is the goal to get this enacted?
Well,
for
I
a
don't,
reason?
I don't think there's anything imminent that this would apply to, especially if it was already filed, there would be grandfathered in. But I do know at the state level, from talking to the individuals who were involved in the lobbying to get this done and who physically drafted it, that it was absolutely, without a doubt, an attempt to basically shut the valve off on the types of lawsuits that, that we're seeing statewide relating to, some third party attempting to tamp down, or delay, otherwise approved development at the state level by, and the trend was lawsuits by quote unquote, neighborhood associations or groups that were essentially specifically created for purposes of initiating the lawsuit to challenge, all kinds of development all over the state. And so the idea was, in order to have standing to do that, you've got to have some property interest at stake. You've got to be the applicant. And, just to use sort of a benign example, if I put in an application to build a fence on my lot line, a 6-foot fence on my lot line, and the neighbor says, well, gee, I don't want that because, I'm not going to be able to see the lake anymore, but that's what the code allows and it's properly issued. We're not gumming up the Board of Appeals with, somebody saying, well, I don't like that, so I'm going to appeal it. and throw everything at the wall to try to block it. No, you don't have any rights at stake here. The individuals that this was intended and set up for originally were the individuals who were denied a permit or denied an occupancy, an occupancy permit, a building permit, and something like that, that was directly affected by the village saying no, or the municipality saying no. That was the original intent of the Board of Appeals, not to basically let any Tom, Dick, or Harry basically come in and try to stop development, or a properly issued permit by saying, well, I don't like the fact that my neighbor got that. Well, what interest or what stake do you have in the matter? So that was the intent and purpose at the state level. And I think it's the intent and purpose here. It would have shut off the valve on some of the litigation we've seen in the last 4 or 5 years. And I think it would do the same moving forward and, save us time, effort, and money moving forward if we change the standing requirements.
If I may, another, I understand your question, but the use of the word strategy, I would say that updating our ordinance to reflect the state statute isn't necessarily a strategy because it wouldn't affect current filings. What it would do is just keep us in line with the statute and then make it much more clear about who has standing. But it's not aimed particularly at any issue that's before the village at this time. Was that what you were asking?
I'm just hearing the commentary about what constitutes a neighborhood association, and that makes me a little bit questioning what's underlying the topic that we're discussing. So that's where my mind is. It, how do we define what a legitimate neighborhood?
Well, that would be, I think the point of the statute is that so we're not necessarily, well, there are two things. So one is that we have contemplated policy in the past to define what it is, what a neighborhood association is or a group. And that was for the that's for the purposes of when a group wants to make a statement for transparency that they want the village to take some action. So was something that was backburnered, a few years ago. In terms of the Plan Commission, we don't need to, I don't think we're being asked. That wouldn't be something that's within the ordinance of having to determine or define. It's more defining who has standing and who doesn't.
The state statute says that the person or entity was not organized or incorporated in response to the application. So that's how the state statute defines it.
I don't know, does that? Okay.
And that's the exact same language we have. We modeled that language in the ordinance. So if
Sorry,
you
but
existed
I wasn't.
before, you might have standing, but if you were organized in response to the application, that's how the statute defines it.
Mhm. So that's another way of saying it is that a person wouldn't need a neighborhood association to have standing, so it sort of separates out the issue. Oh, yes.
Just a couple points that I wanted to make. So the Board of Appeals is not only for zoning and development related things. I believe Nathan and I did a word search for it, and I think it comes up in 23 plus different locations in the code. So it's the same thing if you're denied a liquor license or et cetera, right? So it's not simply development. The reason that we're here at the Plan Commission is because the Board of Appeals language is within the zoning chapter. And the zoning chapter process says anytime you update the zoning chapter, it shall come to the Plan Commission for introduction, followed by a recommendation at the subsequent meeting, followed by then a public hearing at the village board. So just in terms of process, I want to remind you that
Thank
we're here for introduction. We can't make a recommendation tonight, and we're not being forced to make one at the next meeting by any means. So I think all good points. And perhaps, Attorney Bayer can have some time to contemplate, your points and thoughts and maybe bring it back. But yeah, it just wanted to make it clear that,
I appreciate that because I had forgotten.
yeah,
that
we're,
part.
we're here to introduce the topic, in terms of like, is there urgency? There is not urgency. We're here to debate a possible, I have no urgency, Dan, for what it's worth. We're here to debate a possible ordinance update that the village manager asked us to look into. So no different than item number, what is it, 5? I just, when we have the time to make sure our code makes sense for administrative purposes, I'm on board with doing that.
So further comment, oh, and just to recap, Commissioner Wickland, is another way of saying what you were saying, that if the idea of the concept of damages could actually be defined and quantified, maybe that you would support adding that into the,
I would just
Any
say,
update?
reading this, I'm not sure, I'm not an attorney, the thought, eliminating 3 eliminates any person that's not involved in the application from lawsuit.
Mhm,
Neighbor can't make a lawsuit,
mhm,
association can't make a lawsuit, period.
mhm, mhm.
But I think number 3 is probably important. Some people probably thought this through because there may be a situation where an individual is damaged, and if we don't leave them the ability, I think
Mhm.
that's probably not.
So
But
I appreciate that. Any other comments for this evening, Commissioner Klein?
I'd like to ask Bart's opinion. Even though there are other administrative decisions that would be appealable, I'm guessing that given you're involved with zoning and building, that most likely would fall in your lap. I assume you would be in favor of tightening up the groups of people that could appeal your department's administrative decisions?
I mean, yeah, if you look at agendas, it's not difficult to understand that our department is the one that gets challenged the most. It's mostly building permits though. It's not necessarily zoning.
Oh,
Zoning,
okay.
zoning thankfully is more clear. At least that's the hope or expectation. But yeah, Board of Appeals does most likely, receive appeals from things that my department issues more likely than not. It's a building permit or request for variance or special exception. So, like I said, I'm always in favor of making things as clear as they can be. And then just to that point, we're not the gatekeeper of that application. When it comes in, we process it and take it to Board of Appeals, and Board of Appeals decides whether or not that person had standing. So we don't administratively rule on that. So if someone challenges a decision of anyone in my department, we take it in, we give it to the village clerk. The clerk posts it, sends out notices, et cetera, and the Board of Appeals is the one that then hears whether or not they believe it has standing. So it's not going to change anything procedurally wise that my department will do. It hopefully will make the village's job and the Board of Appeals jobs and everyone else's jobs just more clear.
can I ask one more question?
Yes.
This is legalese, but the definition here, they use person, and they mean person not just as an individual, but they probably mean corporation, entity, the way they use it in state statute. But we define like person or corporate or nonprofit. Is that just consistent with ours?
Yeah, I changed the language on that a little bit in the proposed draft. I referenced a corporate or nonprofit association.
No, that's what I'm saying.
Oh,
I
yeah,
saw you
yeah,
did
yeah.
that, but state, they're referring, like, if you look at 4, the one you redid,
Mhm.
for B, the person was not organized or incorporated in response to the application. Person in that is not a individual, it's corporate entity. Person must be defined somewhere in here pretty broad,
It is, yeah.
because
And
no person is being organized for, like, no human being.
right. That's 100% correct. And that's why I expanded on the language
Okay.
for that point. But and I apologize if I get a little carried away on this or a little passionate about it, but this is really something that I've looked into and researched pretty deeply, and probably actually going to be submitting an article on this to the League of Wisconsin Municipalities magazine, hopefully for the next issue on. I've done a lot of research on it and trying to figure out how this plays into with the enabling statute 6223, which is the one that requires municipalities to have a Board of Appeals. And I think we've got it right here. But what I might suggest then is based upon the discussion is it sounds like maybe to craft some language similar to sub 3 that I have highlighted on the statute, and then bring that back for you all to look at. It sounds like, is that what I'm hearing? And
I think that would be a nice, I would appreciate that. Is there anything else that you would like to see at the next time this is discussed? What's that?
It's nice to have Nate.
Yeah,
Thank you.
I'm interested to know, you talked about this being a part of your, is there any way to ask how much time or cost of
Mm. Yeah, we probably have a running time.
your cost?
I
Not that-
would,
not
well,
that you want to take that on as a project.
yeah,
but
I mean, let me work from the general to the specific. And I think that collective experience of municipalities over the whole state and they're, coming together on a proposal like this through the, and lobbying to get this state statute changed stemmed from, statewide seeing lawsuits brought by entities or individuals that didn't fit into these categories and municipalities across the state having to deal with those. So I would hesitate to say exactly, to look backwards and say how many lawsuits specifically Shorewood has had to deal with over the past 10 or 20 years that have been brought by individuals or entities other than those identified in the new standing statute. But I would say it would, I would admit that we have had to deal with those and farm them out to outside counsel through the league. The good news is when we get sued, the League of Wisconsin Municipalities steps in and under our insurance policy, covers the defense, but it still ties up, time, money and resources at the municipal level. So I do think that this would have positive impact on the amount of potential litigation moving forward that any municipality in the state of Wisconsin would have to deal with. I hope that's general enough. Is that?
I see that Barbara Kelly Miller has her hand up.
Thank you, President McKay. Although I don't know any particulars about the lawsuit or who the plaintiffs are that Attorney Bayer referenced, I certainly remember that decision about those residents on Stowell wanting to turn down that parking variance, since Trustee Kudo and I were the only two commissioners to vote against it. But going beyond this particular case, or somebody wanting to put in a swimming pool or a statue on their lawn, if we had an incident where, okay, that lot on Lake Drive that Abley sold and nothing's been built on, if the village were to decide we're going to rezone that and put in a high-rise apartment building, or maybe allow 6 townhouses to go there, or on Capitol Drive, put some, light manufacturing building that butts up against somebody's backyard, I'm certain that the neighbors on the adjacent properties would feel that this was negatively affecting either their property value or their quality of life. So I'm just wondering if you're going to be, I don't know, if boxing yourself in or putting up some barriers to allow residents to address decisions by the government that they don't think are right. And certainly this year, even just a week or two ago, we have seen plenty of citizens in the streets protesting actions by our federal government. So I think it's just something you really need to think about, the implications beyond 1 or 2 particular cases, because it could be taken to the extreme, and then residents don't have any way to redress the wrongs that they feel the village has put into place. Anyway, just something for you to think about. Thank you.
Appreciated. Yes, Attorney Beer.
Thank you for asking that question. It's certainly something to clarify. So yeah, I want to make a distinction between a municipal decision, such as a decision to issue a permit, be it a building permit or an occupancy permit, or to issue a license on the one hand, versus a legislative decision on the other. And I think a lot of the things that you referenced there sounded like legislative decisions as opposed to administrative decisions. And generally speaking, the courts have said, look, when a legislative body votes in a particular way, the review is generally limited to evaluating, hey, did they have a meeting and a properly noticed meeting? Was there a quorum? And did the right amount of people vote? And, you know, was there something like a negative quorum where it was decided the day before? So generally, when it's a legislative body making a decision, the only review that's available are generally on technical issues. The courts don't decide, they don't have the power to evaluate the rationale of the legislator. For example, if the legislator said, little green men from Mars came to me in a dream and told me to vote for this legislation, there's nothing anybody can do about that. It's the power of the electorate to vote them out or recall them. So because once you cross a certain line, you know, you want separation of powers. You don't want courts evaluating the rationale behind legislative acts. So generally speaking, there is no court review of a legislative act. All we're talking about in this particular case is trying to adhere to the intent of the original appellate process or due process that's being provided to somebody who was issued, or in most cases, denied a permit for either an occupancy permit, a building permit, a construction permit, or a license. So if that person says, hey, you got it wrong, you're supposed to, I'm entitled to that. I'm entitled to that permit. I'm entitled to that license. Now they have another body to hear whether they were right or not. So generally speaking, the Board of Appeals already does not deal with anything on the legislative side.
Thank you. Trustee McGovern, did you? Nope. Okay. I think we can close discussion on this item and expect it to be agended for our next meeting.
Thank you. Thank you all for your questions and discussion on that. And I will take that and bring back a revised incorporating sub 3 from 78110.
All right, thank you. We will go back to item 3, further discussion of the Plan Commission's proposed initiative to increase housing opportunities in the village. This is coming back to us from the planning director with a couple of items in red to be discussed and considered. To the extent that the Plan Commission has recommendations, I would suggest that we just walk through using the PowerPoint that has been provided.
And apologies, Barbara, can you see my slides? This never seems to look right in my end of things.
I can. I'll let you know if they don't advance.
Okay, but you can currently?
I can, yes.
Okay, perfect. Thank you. So yes, to President McKegg's point, for the past several months, we've, as a Plan Commission, have been meeting to discuss 4 topics that were identified in terms of possibly increasing housing opportunities. As I mentioned in my memo, I don't believe, as the planning director for the Village of Shorewood, that any of these will have huge impacts. They're all minor. If that, we're not talking about rezoning large swaths of property or, you know, increasing height restrictions, et cetera. But they are important in terms of what people read and how we're expected to administer the code. So just yeah, there you go. So when we left off last meeting, it was discussed that we kind of wanted to firm up where we were at with each of these recommendations and identify anything that needed to be more specifically asked through public engagement. And so once we get through these items, then we'll discuss what type of public engagement you'd like to see. Back to a previous question, there is no rush on my end of getting through these things, other than it'll be nice, you know, to move on and do other projects, obviously. But if there are questions or if we need to pause anything, feel free to let me know. The first one we discussed, you know, several months ago, so hopefully it's not too gone from your mind. But the main change here would be to change it from 3 adults of any relationship to 4 adults of any relationship. The standing point of that was, you know, 2 adult couples can't share a house or an apartment right now because 4 people isn't allowed. So we reviewed some other codes, and my understanding in the minutes that I think I shared within the memo landed on this as the proposal. So are there any additional comments with this? The rest of it is kind of cleaning things up and making sure that we have, you know, civil unions, domestic partnerships, legal guardianships, all properly termed in there. And so if there's any other comments on this, otherwise, the question is this ready for public engagement? The primary question is going to be, I'll show examples of, you know, potential households and show which ones can or can't currently in the code. occupy a dwelling unit and just ask attendees, whether or not they think that's something that the Shorewood should regulate. So we'll start with this one perhaps.
All right. So to recap, we got to this point because at our last meeting, the consensus was to go with 4 adults over 3, although it wasn't unanimous. So the ask would be to move this definition forward for public engagement unless there's further points of discussion or for points that we should consider. Commissioner Wickland?
Yeah, I'm still against 4. I think it should be 3.
Okay.
I think even the example you gave doesn't need 4. 2 couples living together, that's a domestic partnership. That's the definition of a domestic partnership, is 2 people in a relationship. So have 2 couples live together. I just
Not-
looked up domestic partnership.
Well, not under our current, so but you're gonna have 2 domestic partnerships, and that means that this partnership is not related to this partnership. And so we currently don't allow more than 3 adults. We'd have to change it, in my opinion, and in talking with the village attorney, we would have to change it to 4 adults to allow 2 couples of any kind to cohabitate under the current definition. So I can reconfirm that if you'd like, but that's where that's coming from.
If you could reconfirm that, that's 1. 2, I think that reason, I looked this up last time after I know everybody's a fan of 4, but the reason why this exists across the board, not as 4 typically, is to prevent student housing from popping up, rooming houses from popping up. We happen to border a university. And so keeping it at 3 just tamps that down a little. Now, is it going to be a huge issue? I don't know. Probably not. Is this going to be an issue at all? But also changing it from 3 to 4, does it ever matter? Does it matter? By having it in there, it does leave some enforcement mechanism if that does pop up. Second, we change it and get rid of it, doesn't. I don't think we've been enforcing it all. 6. I mean, I just don't think this has been a huge issue. We talked about that last time. But by changing it, you open the door to people abusing what we've put into my opinion.
Appreciate it. Other comments, discussion? Okay, hearing none, we would move this forward for public engagement, noting Commissioner Wickland's comment, which probably is going to be echoed by the public engagement. So item 3, housing opportunities.
Yeah, so the next one we reviewed was bedrooms and basements. This one I don't recall hearing any opposition to. We're the only code that I know that has this. In my opinion, the building code protects the life and safety of any sort of dwelling unit in the basement, but currently the zoning does not allow it. So currently, I take that back. This is in the property standards, not zoning. Currently, the property standards section of our code states no space in a basement or any R district may be used for sleeping purposes or as a dwelling unit. So you've got 2 things there. Sleeping purposes would be a bedroom of a current unit. As I mentioned, that in my opinion and in everyone that I've talked to, that is safeguarded by the building code, making sure there's egress window to get out, et cetera. And then the second one would be as a dwelling unit. If we were not to change this, we would be essentially limiting a potential accessory dwelling unit from being in a basement if in fact we go that way. So once again, I've talked to every municipality adjacent to us, and I've never seen this anywhere else. So the question would be whether or not the village for some reason thinks that we should, maintain this prohibition.
All right, so to recap, the consensus of the commission is to eliminate this item. Additional comments? Do you feel it's ready for public engagement?
Yes, I think it's ready for public engagement. I think a lot of people would be surprised to know that a prohibition even exists.
I would
They
agree.
pulled their permits.
I know, right? All right.
Be a big rebel by sleeping in your basement tonight.
Mhm. All right. Thank you. We can close this item and move on to the next. Accessory dwelling units.
So this one was the biggest conversation of all the ones that we've had. And I will just say for reference, we received a call this afternoon about someone asking whether or not ADUs are allowed. So we do get calls probably 5-6 times a year. So there is some interest. I can't say that those will, become actual units because people need to research, cost, et cetera. But currently we do not allow ADUs. ADUs would be classified as smaller independent residential units, accessory to the primary residential use. One of the questions that we need to discuss tonight or get public engagement on is whether or not we want to allow them only with single unit buildings, traditionally what we call the single family house or a duplex, which in turn would allow 3 units on that property. ADUs can be internal, attached, or detached once again. So an internal unit could be in the basement. If we get rid of that prohibition, it could be in the attic. It could be in the back of the house. And they're not currently prohibited, as we mentioned. We did look at one example of what this looks like in reality. So this is not occupied on the second story as an ADU, but contextually wise, it is in the neighborhood, and I've not received issues or complaints. Now, mind you, no one's living in it, so there's not an additional household, but context wise, this was the example that I was able to find. We did, or I should say, I drafted various regulations based on other examples, whether they're national, regional, local. And where we left off with last meeting was there were several things that the Plan Commission didn't really have a lot of spectrum of opinions on, but there were some that needed to be discussed that we discussed we would put towards the public, bring those back to you just so that you have some references. So once again, the first question would be, do you want to allow these both at 1 and 2 unit residences, or just limit it to 1 unit residences, essentially saying a 1 unit can become a duplex, but a duplex cannot become a triplex. Now, I said that inappropriately because this is not duplex or triplex, but you're talking about 2 or 3 households living on the property. So unless you want to remove that discussion point, that would be the intention, to ask within public engagement whether or not there's an appetite to limit it solely to 1 unit residences.
So would you like this item included for public engagement?
I'd like to include it with public engagement. I'm curious to see what people think.
I agree.
And in general, I drafted these, in my opinion, thinking it would be nice to get public engagement on them. Maybe I'm kind of asking, like, is this the only question that needs to be asked in this one, right? So this is a question. Are there other questions? I don't think so. If I think of them, I can definitely add them to it, but I appreciate both comments with respect to wanting to hear more about that. Just by their nature, no more than 1 per lot. It's an accessory dwelling unit, right? So you get the 1 of them. I don't have any questions on that. I think that's pretty straightforward. Once again, it would be internal, attached, or detached. If for some reason the community only wants to see these internal, that'd be a big change from how other communities allow them. But I will put that out to the public in terms of this is what the regulations are proposed to include. Size is one of the more interesting ones. Currently, or I should say the previous draft that I shared had 1,000 square feet. That was based on Milwaukee. Maximum square feet, they have 1,000 or 1,300. Wauwatosa's allowed them to 900 square feet. Wauwatosa's had problems with people finding them to be feasible, in part perhaps because they're not large enough for someone to make their money in return off of. So I guess the question that we'll be asking is, the maximum size of what an ADU could look like from 900 or some other number up to the size of a principal dwelling. I share that size of the principal dwelling. That is currently what the state statute, there's a bill floating in the state legislature that would allow ADUs by right in certain cases, and the language that I've seen says up to the size of the principal dwelling. So whether or not we want it to be smaller, we might get overruled on that if that goes anywhere. I have no crystal ball on that, but there are options in terms of smaller numbers up to the height, up to the size of the unit, which essentially would be creating just less than a duplex. Lot coverage is another interesting one. So right now, our existing lot coverage ratios are 30% for the principal structure and 10% for a detached accessory structure. Green space has to be maintained at least 30% on the lot. The question is, do we want to keep those existing envelopes and say, your principal structure can only be 30% or 10% for accessory, no matter, whether it's 1 unit or 2 units or however that works? Or do you want to work within the building envelope and say, we allow 40% of the lot to be developed with structures? And if this, if this facilitates the development of a slightly larger accessory structure because your principal structure isn't 30%, is that something that you want to do? So this was discussed in terms of the scope of, are there ways that we can make this more feasible to people? So that's how it's currently drafted. That's the perspective I'll share. If the community has a clear answer, I'm happy to advance whatever that might be, but there are ways to think outside the box on those percentages that still wouldn't go above the 40%. I'll pause for thoughts or comments on that if there are any.
To make a comment about the lot coverage ratios, that if there's some way to conceptualize that for the public, either in scenarios or photos or examples, I think sometimes these percentages an abstract.
Great idea. Absolutely. There would definitely be a way to show that because one of the more interesting things that we, administer is, right, if your garage is attached to your principal structure, that's not an accessory structure. That's part of the principal structure. So there are lots in the village of Shorewood that don't have accessory structures, and they're limited to 30% on the one that they are building because it's attached. So there are numerous scenarios I think that we could show, perhaps that might help explain what that looks like in terms of the real world administration of lot coverage. So I've made a note on that. I think that's a good idea.
Dan?
Yes, I get what you're saying, because with lot size, Shorewood, decent sized lot is like 1,000 square, 10% of that, looking at 600, not. So I get it, but what happens then, if we say, okay, it could be 40% with structures, do we allow then people to start building garages that are 20%? Like if they're, it just gets complicated, I think. Like,
Yeah,
you can build a garage if it's 10%, but you can build a dwelling unit if it's 20%, as long as your house is only 10. It just, I don't know.
Yeah, that wouldn't be my expectation. And you're right, it could be difficult in terms of administration if someone says they're going to build it as an ADU and then ends up using it for some other purpose, right? But
Well, plus, why do we want to stop someone from building a bigger garage, but not a bigger place that has more people too? I mean, the garage seems like less impact on the village in general. If it's about looks, probably stick to, I'm just bringing these things up.
yep, that's a good question outside of the residential conversation. And perhaps if you allow it in that case, it makes this discussion, go away because anyone can do it for whatever purpose they want. So I think that's worth, asking as an option as to whether or not we should currently do that with garages or other structure maximums.
I think we should keep the green space requirement there.
Yep, I hear you. I've heard, people complain about not having enough green space with respect to drainage or open space and whatnot. I will say that that's not something that we can easily regulate because people don't get permits, for small slabs of things, and we're not measuring all 30% every time. So there is a kind of misconception that, we have a lot of control over that, but I'm not suggesting that we get rid of it. I would not recommend changing setbacks. Those are pretty standard. And once again, you can get a variance from the Board of Appeal if by chance you have, unique circumstances. So no need to change those in my opinion. And then there's just a few more. Height is one of them that I have received a comment on that from the public with respect to people don't believe that you can, build a small unit with small ceilings and make it worth it, right? So the question is, I had drafted it to not exceed 20 feet if detached from the residential unit. Once again, if it's attached, you can be in the attic. So that can be higher than perhaps your ADU, but historically you've not allowed accessory structures to occupy that much space of your rear yard. So if by chance you wanted, to include it with your principal structure, you could go up to that current height. The current draft wouldn't allow your accessory unit to go up to that height as well. So but I did receive a comment on that. That was my response in terms of if you want to have your attic converted currently, that would be the option to go above that 20 feet. And I believe the state legislation's draft would be the same height of the principal structure. So once again, we could be overruled by that if that does in fact go anywhere.
But then again, do we allow people to build garages the same height as the principal structure going forward? Because again,
Correct. So my draft didn't have that changing. And my response was, if you wanted to go higher on your house, not in the accessory structure. But if the plan commission and board wants to change it for all structures, garages or ADUs, I have no issues on my part in administering that. I think parking was the one that perhaps is the most discussed, naturally. So the scope of options that I heard and or recalled from last conversation was, on the conservative side of things, we could maintain current requirements for both principal and accessory units. That would be very limiting in terms of how you get that much garage space on your lot. Secondarily, you could allow unenclosed parking spaces to qualify for those requirements. So once again, can you park 4 cars in the driveway? and not have them in your garage. Is that acceptable to the neighbors? You know, to expect 4 cars to be parked there if they want to. We're not currently enforcing that. If it's a space, it's a space. It doesn't just count towards your requirements. Third option would be to eliminate the requirement for the accessory unit. So, you know, if you're building an accessory unit, that one doesn't need to have parking, but your principal one still does. Or the most, you know, open-ended of things would be to eliminate requirements for principal and accessory uses. You know, in recognition that housing is the goal as opposed to parking, which could be accommodated either once on the site or on the street. So I think those 4 encompass what I think I need to understand more from everyone. And I do think that has been the one that's been most discussed or debated. The last one is a short-term rental prohibition, which we can, you know, put in the code. It's just difficult to enforce, but there's no issues putting it in there. So once again, back to parking or anything else that's in here, but that's the scope of the changes we sought or we discussed last meeting. And then these are the questions that I heard that need to be pulled out within greater engagement efforts.
And I'll just reiterate what I said at the previous meetings is just, I'd prefer to be as flexible as possible on parking and not have, you know, we're going through this whole process to try to increase housing. Other communities that have done this have seen very few actually get built. So let's not bog it down even further with, you know, parking mandates, and let's just try to be flexible and let people build these if they want, not put an additional requirement for parking. And I think if we do get these built in Shorewood, it's probably not going to be in places where there's, you know, shortage of parking. To be residential areas. You know, we've updated the parking code to make it easier to park on the street. So I think this is something we should just be flexible on.
Yeah, I agree with flexibility. I think we should, I don't understand. I think we should maintain it for the current structure, not require new parking built in ADU, but not, you can't get rid of your parking in lieu of putting in. Now we're getting rid of parking that was required before and adding people. You know, again, like, I don't think we'll have many of these, but if that's my neighbor and all of a sudden one spot in front of my house is always occupied because we allowed them to get rid of parking. Plus, we're gonna probably be allowing 4 unrelated adults, but dude, now you got a lot of cars. So I think you combine all this together, you may create issues with.
My
Mhm.
comment, I agree. Just shared in my, on my block in the alley, we have multiple people that park on slabs and they don't want to pay the fees to do on-site parking, and that could be something that the village looks at in connection with this. But yeah, I'm just imagining there's going to be more cars tucked in every last little into off of our alley.
Yeah, that all makes sense to me too. I guess so with that sentiment and consensus from this group, I'm wondering if we could shorten the item under parking. Let's see.
I think I agreed with what was there in black entirely. To
Oh,
do
right.
where you were saying like get rid of parking. Because in black, it seemed like that's what we got to last time, and now the red starts to muddy the water.
That's what, yeah, I feel like the red asks like micro questions. It's a lot of engagement. And I'm not sure if we would walk away with like clear themes.
I hear you on that. That's a good thought.
So maybe like, yeah, the black, and then for trustee McGovern's, you know, constituency, like what would be the one question that you would ask of those 4 questions to get an alternative? Do you see what I'm saying?
Yeah.
I believe what I heard his option would be to eliminate requirements for principal and accessory uses, as opposed to just eliminating them for the
Right, so
accessory.
it's like either this or the extreme, the other.
I don't want to speak on your behalf, but that's what
Yeah.
I heard. Is that
Yeah. I mean, that would be a question to include in the public engagement. See what people.
Again, we would eliminate it then for not just ADUs, we would just eliminate the park. Because it'd be weird again to eliminate it if you're creating more need for parking. Eliminate only for that reason, but not eliminate for, let's say, I don't want parking. You know what I'm saying? That's why this gets complicated.
Mm-hmm.
And the
But-
complicated part of that is we know of many houses that have a garage they don't use for parking. And so
Right.
we don't,
And
we
we're
don't
not
currently,
enforcing that.
we don't currently enforce.
Well, because that's
The-
legal, you can
The
use your
code
rest-
requires you to build it. We don't require to use it that way, right? So, yes. A larger question would be, since we don't or can't enforce that, is it worth even keeping on the books?
It just seems weird that we always talk about being in this village, like it's the most important. Getting rid of the requirement to have parking at your house might be not a real. But it just seems like
Okay.
changing the rules. Do that, just.
So, but getting back to the point of this, so one way of that is hearing sort of consensus or input from this body in terms of the importance of parking requirements or lack the, flexibility around those. But for the purposes of public engagement, I think the point I was trying to make is that the way that the red part is worded is pretty confusing. So, if we want to get public engagement about alternatives, if there can be a more direct way to do that. But I understand wanting to open it up to that the parking item, what's described in black, is sort of the consensus of the group. Trustee McGovern is looking for public engagement around, would it be tolerable to alter parking requirements, and what would that look like? I don't really have much to add beyond there. I'm just thinking of the practicality of doing public engagement with the way that is written. Similar to, it's hard to conceptualize some of these ratios and things like that. Yes.
Just thinking, is there a way that we can look to other municipalities that have specific topic to see how they did it? Because parking is something, when you look at ADUs, just generally speaking, parking is one topic that comes up right.
Yep, those examples were provided in the previous
Oh.
discussion, which is where we ended up landing on this. So my
And
memory
what
of
I mean for
Milwaukee
the-
doesn't require it at all for any residential use.
I mean, for the
Sorry.
community engagement part of it, like
So-
taking, utilizing, here's how this was presented in a different municipality to the community. To get at, to ask community.
I'm confused on that because we're asking whether or not. I mean, I've always been
How to present
guided
this
by
to the
asking what
community.
Shorewood wants, right? As opposed to saying,
Saying like at the community thing, just showing them like, hey, here's how other communities have done.
Yeah, and just even looking at
know, we-
like, even looking at like, this is how their open house was handled. This is how their survey was created. This is the way the questions were framed,
Mm-hmm.
just like a
I would love to
process.
have access to that type of.
Or did you do public engagement?
Did you, right, yeah, like all of. I'm making more work for you.
Barbara's
Right.
gonna be the only one at public engagement.
I guess I don't want to spend, we've been here a long time, so I don't have wordsmithing on this, but that's just my general feedback. So there may not be a solution, and if it moves forward like this.
Yeah, and I
So
just
be
want
it.
to cite one example just for why I keep harping on. So like my house, I've got a 2-car garage. There's 2 parking spaces behind it. Let's say I want to turn my garage into an ADU, which I don't. I'm not going to build an ADU. But let's say I did. If I have to maintain existing parking, that's not allowed because I've gone from 4 parking spaces to 2. So if the purpose of this is we're trying to find, new ways to get housing. We want to have ADUs. We want to at least discuss it. Maybe we don't end up doing any of this, but we want to throw this out there to the community to say, what do you think of all this? That maybe we should allow people to get rid of some of their parking if they want to use it for an ADU. That's why I brought it up and keep coming back to that.
much parking, how much, what is the requirement?
One per unit, and in a residential district, it has to be enclosed, so it has to be within a garage.
Okay, so maybe-
Yes, those 2 spots on your driveway don't count as parking spots.
Yeah, and that's my point is that, you know, so I wouldn't, that's my point is that I wouldn't be able to do that because I'd be getting rid of my enclosed garage parking spaces.
Oh,
And I would only
swapping it
then
out
have,
for unenclosed.
like, I could be able to park in my driveway or park on the street, but since I'm getting rid of my enclosed space, that's not allowed.
Correct, which is why one of the options I had would there should we allow unenclosed parking spaces to qualify?
Yeah, yeah.
Like
so
that's the one that's most relevant. That's the question that's.
Yeah, so that maybe that's how we get at that is to
So rather
say,
than eliminating the current need or the current requirement,
Mhm.
modifying the current requirement to allow for the space to be unenclosed.
That,
Right.
yeah, that seems like the thing that would be, provide flexibility, mirrors what people are doing already, which informally, and would allow, create more opportunity for ADU.
So someone then could build, one of these new houses could build a house with no garage.
If they had a parking slab or a
Right.
driveway.
Right.
I just looking at and then I'm wondering though, one more suggestion. I know we're
Yeah.
beating it down. Maybe to what you're asking for too. No additional parking shall be required beyond the current village ordinance, because you would then be able to convert one of yours to an ADU. You'd maintain the one existing one for his current residence, correct? He doesn't need to have 2 spots.
Correct.
You only need to have one.
Currently, it needs.
Otherwise, we're just eliminating the need for any garages at all whatsoever, which, by the way, people probably like garages of them, but I'm just saying that'd be unusual, probably in a municipality like ours to not require,
For new construction.
or period, but yeah.
yeah. I mean, it could be existing houses too. Like, let's say you've got an old house and your garage is falling apart. Maybe you just want to level it and may have a bigger backyard, but you're not required to have a,
And that
enclosed
question
parking.
does get asked.
yeah.
It's
And
a
we don't
really good
allow it
point.
currently.
This isn't an
Wait.
ADU discussion, really. This is more of a parking.
Yeah,
parking
you're blowing my mind right
Yeah.
now. Okay, so,
You want
for
cars sitting out.
right. Then they're gonna be up on blocks and people are gonna be working on them. What, for the purposes of tonight,
Question,
yes,
need to be, taken to school, public engagement, to be some type of like a public workshop that, that Bart would conduct or?
So that's the next question. So in the memo, I suggested 2 different options. There could be an online webinar type version where that would exist. You know, we could post it, people could watch it at their own leisure. Or historically, we have done in-person engagements, which in my opinion have been not well attended, and you know, don't get a lot of new commentary, but that's historically what we've done. So if there's other options, I this might come off as rude, I apologize, but like I just want to remind you, this was the Plan Commission's initiative, and so I'm happy to do what you guys need or want me to do on that, and I appreciate that, you know, I can offer things, but I want to make sure I'm meeting what you're thinking on this is. And back to my point of like, there is no time frame on this. We're getting to the point of the year where holidays, you know, interact with things, et cetera. So I don't want to jump the gun, but the next question really does kind of ask that question more specifically of what type of engagement would you like to see? Because at that point, then I would bring back the engagement. The most successful thing I've done with respect to engagement recently has been an online survey that was with the traffic demonstration activities. I received over 570 comments. You know, it's in the ground. People definitely had opinions of that. So I might not get that level of interest in this one, but I do think being able to push it out beyond the activity is important. So yeah, it would be, there would either be, you know, a board or an example of what this is and asking people to comment or do a survey on it.
To Bart's comment about no timeline, I think it's what, like the fourth meeting we've had this?
Mhm,
I mean, I think it's kind of time to fish or cut bait.
mhm.
And I guess what I would suggest that, Bart, I think you heard a lot of comments. I would suggest that you put it in the form of an ordinance and bring it back, and it'll go ahead or it won't.
And that is
people-
one option. We wouldn't have to do additional public engagement. We could just do recommendation, public hearing at the village board. And maybe not all 4 options need a public engagement, right? Maybe that bedrooms and basement one, you don't want to ask that question because it's too obvious to you, right? So, yeah, that is definitely an option to bring back a draft of all of these things as we heard. The questions will remain. Those questions, would be asked within the public hearing, perhaps.
I like that one. So we can just get this done.
Point
Then you have
taken.
less work too.
I favor a survey because I think that people don't have time to devote to coming to a meeting, even a webinar, but they might open a survey and click through some questions.
Especially if it can be simplified.
We hear it at public hearing, as
Mhm.
presumably the village is public forum.
Yes, so this is where it's probably my bias, but knowing the board, the current board that we have really values public engagement, and
Understandable.
so taking that step. So I think at least a survey component before the public hearing would be appreciated. It'll help the board. I would think it would help the board engage this initiative and understand what they're being asked to
Make
do.
sure it's properly vetted.
Exactly.
But I guess what I was suggesting, Bart brings ahead an ordinance based upon what he's heard here, as well as his own professional opinion.
Yes.
And it stands or it falls, it gets amended, whatever.
Mm-hmm.
And I could bring the survey back to you at the next meeting as opposed to, doing a public, I could, in November or whatever next scheduled meeting is, I could say, here's a survey I put together. Do you have any comments or thoughts on,
Yes.
take question 4 out, modify question 6? I don't know how much you want to, be involved with that, but if it's something that people are interested in doing, I'm always happy for feedback.
Who's ready? Who would like to create a survey? Okay. So maybe draft and give feedback.
I mean, I could assist.
On all 4 topics, is that generally what people would like to see?
Mm-hmm.
I think residents are used to having an opportunity for input. And there's a lot of interest in ADUs in particular. So I feel like this is an opportunity for education as well as engagement. So if there are things that you, Bart, as planning director, village president, want to highlight it within the survey, it's an opportunity.
I think, and actually I could see back to the point of, do we include all 4 topics in the survey? Accessory dwelling units probably are the most it's the most complicated and significant change. So maybe even just focusing on, and it's the most technical, I think. So maybe even just having the survey pertaining to ADUs and then bringing the other changes forward as just kind of updates that are based on Plan Commission consensus.
If that's the
Thought-
direction, yeah.
I would agree with that. I think it would get more interest too. People see an ADU survey versus housing opportunities, which
Yeah,
is
it's
a little
pretty-
bit more general.
Thoughts?
They want to do it. I was more. Let's just draft the ordinance, make a recommendation, and let the village. But if that's not what the village board wants, money in their hand.
Mm-hmm. Okay. So I'm hearing actually kind of a 2-pronged approach. So move ahead with ordinance drafting for at least 3 of those, and then do a survey and what about drafting all 4 and then putting a survey out specifically for the ADUs with the draft language somehow? We might be overthinking it. I think that if the ADU ordinance comes to the village board without some type of public input, I think it might be hard for them to move forward. Is that,
Yeah.
do you agree with that? So I'd say draft the 3 and then do a survey about ADUs, draft that. Or we could take the 3 and then do the survey, bring the ADU language separately to the village board. That might be good too.
No survey on like household.
Good point. We had pretty different sheet.
And maybe it isn't. I think the basement thing,
Mm-hmm.
anyone's ever said.
Mm-hmm.
And as we do have one more topic, just for memory's sake of to re-allow duplexes in the duplex district. So in 1983, that option was removed. And so what I heard, I think from consensus last meeting, was to move forward with asking additional public comment on that, but then noting that in the past, all residential districts allowed duplexes, not just the R6. But I did not hear desire or permission to go that far within public comment. But I guess I'm here for thoughts on that as well. Yeah, the only confusing part to me is that we have properties zoned R6, which says 1 and 2 household district. And then people read it and they go, wait, I can't have a duplex in this. And I say, yeah, that's weird. They never changed the name of the district. It's only allowed in like this very random circumstance. And so if the village didn't want to allow duplexes in R6, at the very least, I would suggest we then modify the name and just call it something else to avoid that confusion. But the confusion that we get from people asking is duplexes exist in the R6 district, but you can't build a new one in the R6 district. So we would
You
just
build, if you, where one exists, could you build a new one?
I'd
Yes.
have to look at the language. At
Again,
that
this
point,
goes-
at
this
that
goes-
point, it becomes a vacant lot. So there's nuance to how it's written.
I think actually you can't. I
Yeah,
think
this
that was
goes-
part of it.
We had talked about it before. This goes
Yeah.
back though to, now we're removing standing for a neighbor to even sue potentially for the village granting somebody to build a duplex next to them because it may devalue their property. They're like, hey, we had single family residences and now you built a duplex next. That changes the property. No,
Right, there's no proof. That's, get me
Right,
started,
but that's what, right, but I'm saying
there's the
like,
perception of it.
right. Why even open it up? Is it gonna be a big thing? It's expensive to do these anyway, but why? And again, bring it 1983, go back to 1956. Why not everywhere?
All right, it's 8 o'clock and we can continue and close this out. Initial support for moving forward, getting input on allowing duplex, updating the R6 district to pre-1983 or updating all residential districts.
I mean, I'd be in favor of allowing duplexes in residential districts pre-19, or at least getting public comment on it. But I think it's, the purpose of this exercise is try to find ways that additional units. There's probably, again, this is going to be something that's not going to come up very much, but if there is a vacant lot, or maybe there's been a duplex that's converted to single family and someone wants to go back, I think again, just allowing that flexibility is something that should be a goal.
Yes.
I also tend to favor allowing duplexes in all residential. I'm also thinking about how much community engagement we did with. And so if we are going to be tackling all residential districts, then that does warrant some very strategic, involved community engagement.
Yeah, I'm definitely thinking that adding all these up, I'm just thinking of myself as a resident with no context, getting a survey and then being able to really engage in it. I mean, maybe that's not something that I need to worry about. But in terms of meaningful engagement, there's a difference between just doing it and really setting it up to be meaningful. So I'm going back to, I feel like the accessory dwelling units is the policy that we get the most questions about. And whether or not they're feasible, and how many we would have is not what I need to worry about, but I think that we should prioritize moving that forward. And maybe holding this one for more discussion for early next year, unless there's a big initiative that we really need to move on to. And I think Commissioner Wicklund, you bring a really good point about the household size. It seems like going from 3 to 4 might be really significant for people, and we should know. And the village board should have the advantage of having that. Agree that basements, it's like eliminate or keep it, but that is only one question. It's not that technical. I would favor doing a survey with the first 3, not the 4th. This is the 4th one, right?
Correct.
And I'm all right with that too, because the ADU one does have a lot of sort of sub questions, so maybe that's just easier. If I do one at a time, one bigger thing.
Mhm. And we've done all the background on this duplexes one, so it wouldn't be that much to kind of bring it back. But
I
Yes.
would just say I agree with prioritizing
okay,
over the.
thank you. Yeah. So does that give you kind of enough? And would the Plan Commission allow for me as chair to, work on bringing this forward with Bart, given the direction and balancing the need for public engagement versus moving these forward and not getting lost in the minutia? And then Commissioner Flynn Post to advise on survey development. Is there anybody else who would like to be involved at this point? Would you be satisfied with us supporting Director Grapentrog to move this forward? Great.
I'm right behind him.
All right. Thank you.
The
We're going to balance that. We're going to get these to draft, but also engage the community at the same time.
So I did not hear a need for Commissioner Flynn Post and I to bring back the survey to the group, or would the group like to see the survey?
Would the group like to see the survey? Nope.
Okay, so, okay, all right, thank you.
Let's get it done. All right. We have one more item.
We do, once again, this is an introduction of a possible change to the zoning code, which does require the introduction, a subsequent recommendation, and village board public hearing. So within the, if I may,
Yes, please.
I can read it, I guess.
And it's not as complicated as one looks. It's pretty nuanced. I mean, it was just an oversight, but it's substantive.
It was
so.
definitely an error on my part, and it's been brought up to my attention several times. Again, when we had the request for rezone with Mr. Bergholtz last month or 2 months ago, their lawyer pointed out that if you read it technically, the upstairs could not be used as an office. That was not the intention. I would like to clarify that. So just for a matter of the record, introduction of a possible amendment to the zoning code with respect to clarifying the location restrictions of office uses within the MX district. So as I think many of you recall, perhaps not Commissioner Klain, in 2024, we did, and I apologize, I don't remember what the Plan Commission recommended, but the village board did allow for a location specific opportunity for office uses in the MX district. Typically, office uses are not allowed because they're seen as more dead storefronts. They don't have a lot of activity associated with them. So the draft as done in the commercial zoning update only allowed them in the rear or the upper story, acknowledging that the storefront should be more occupied. In 2024, we received an application from someone who had a very large storefront saying that's never going to be feasible. And they requested consideration of how to allow it in that large building. The board did ultimately adopt that with a limitation on the total frontage or percentage that could be occupied by the office. In drafting that, I made an error in using the wrong symbol in discussion, and I totally own it. So in doing so, I inadvertently removed office uses from upper stories or the rear of the ground floor. They're currently technically only allowed with qualifying restrictions in those large buildings. So you probably can't read this, but this is the current table. When I made it a full circle with the asterisk says only in these cases can you do that. So once again, for introduction tonight, and I can answer questions and discuss it further. There is no time frame on this, but I would like to clean it up just because it's been brought to my attention. I would like to revert office uses to that half moon open or closed in the top symbol, which says they're permitted as of right in the subject zone, but only when located above the ground floor in the upper stories of the building or in the rear of the ground story 20 feet behind the primary facade. So this once again is what it used to be. I didn't intend on removing that. And then I would reword the exception language. So right now it's a requirement. Here I'm saying it's an exception because that's actually what we intended to do was allow for an exception for a large building, not say only when you have a large building. So I realize this is very wonky technical zoning stuff and we're, an hour and a half in, but the new language would say as an exception, uses also identified with the asterisks may also be located within the primary frontage of buildings with at least 120 linear feet of primary frontage, so long as those total uses, not including the lobby, occupy no more than 90 linear feet or 50% of the frontage along the primary facade, whichever is less, but in no case shall they be located along the primary facade within 60 feet from a street corner as measured from the corner of the building. That doesn't change anything other than making it an exception rather than a restriction. So if you have a chance to review it and you have any questions, either now or in the next month, I'd be happy to try to walk everyone through on that. Once again, we're here for introduction tonight. It's possible that we could recommend modifying that or updating that at our next meeting if we have one in November with a public hearing in December. Once again, I'm not in a huge rush for this. It was just brought to my attention and I feel bad that I did it, incorrectly. And so it'd be ideal to get that cleared up.
So this is basically a housekeeping.
Yes, it's too big for a scrivener's error because it's definitely not a typo. But in my world, it's a housekeeping item to correct my poor draft.
So the zoning code that was produced didn't properly reflect what the action of the village board.
No, my draft went further than I thought it was when I read it, and
Okay, so you.
I didn't catch
presented
it. The attorney didn't catch it.
incorrect-
No,
Okay.
no one caught. I think we all assumed that, my language, that I drafted it with the right wording, and that's definitely not the case.
I'm
It
not gonna
happens.
make any more mistakes this year because I've used all mine up. So I'd say move ahead next month with your.
But yeah, I can provide that for recommendation at the next meeting. Like I said, to me, it is housekeeping, and it's just fixing an error that I didn't realize I was making.
All right. Any
We
further?
have to go through all of these.
We do, and I have no problem with it. I mean, it's introduction, recommendation, public hearing. It theoretically could be done in the next, 4 or 5 weeks. So
Thanks for asking.
Very upsetting.
I'm with
Don't
you.
let it happen
I'm with
again.
you. Once I realized that I was upset with myself for not catching it. So
Do we have to do the meeting before the hearing, or the preceding? Do we have to do that?
Yes.
Same with housekeeping.
if it was a scrivener's error where like I just typed the wrong number, I definitely probably could have worked with the attorney to get that done. But I did more than just use the wrong symbol. I used, different language. So I don't want to, hide that from anyone. I just want to get it fixed.
All right. If that's all the discussion on that item, I would ask for a motion to adjourn.
Motion adjourned.
Commissioner Wickland, motion to adjourn.
Second.
Second by trustee McGovern. Any objections? We stand adjourned at 8:11.